Hey friends, good morning and welcome to Stocks and Crypto Plays. I'm going to talk to you about the newest Judge Zurn letter that was just released and what it means for you and I. Okay, this is the newest one just out. And then I'll basically what I'll do is I'll cut away to the letter so that you can see it full screen. I'll be on there reading to you, pointing things out, and I'll fade back here to me full screen. Okay, that's the format for today, friends. Okay, so we've got a lot going on with AMC stock and a lot going on with this court case. All right, so hit like, subscribe, add notifications, share the video with a friend. Let's see what she said together. Okay, let me pull it up for you now, and then I'll see you back here after the letter. Okay, here we go. Okay, friends, as you can see here, July 24th, this is dated here. AMC Entertainment Inc. shareholder litigation. This was released. It says, this is from Judge Zurn. It says, Dear Counsel, I write in response to two recent filings, the parties of July 22nd, the letter, and Rose Izzo's motion for clarification or alternatively for maintaining of status quo order pending appeal, the motion. So I noticed right away, immediately there, she does not address the fact that Izzo wants to be the new lead plaintiff. Let's take a look here. The letter enclosed an addendum to April 7, 2023 stipulation agreement. The addendum revises paragraph A1. Release the parties of settlement. Okay, we know that. Release plaintiff's claims. Let's see here. So basically, what they did was they struck AMC preferred equity units from the release of the plaintiff claims. You see that in bold where they struck that and or AMC preferred equity units. So the release plaintiff claim means any and all action, causes of action, suits, liabilities, claims, debt sums, and it goes on to do all this legalese jargon where it's basically saying that you cannot sue if you own AMC or APE after this, if you accept the settlement. But then it goes on to strike out AMC preferred equity units. The revised proposed order reflects the addendum. In the letter, the parties request, 1, that the court approve the settlement on the revised terms and pursuant to the enclosed proposed final judgment, and 2, that the court stay its order directing the plaintiffs to submit a consolidated complaint and the parties to submit a schedule for the remainder of the litigation. The parties argue additional notice need not be provided prior to settlement approval because the changes to the proposed settlement do not adversely affect the class. The motion seeks clarification as to the effect of my July 21 opinion on the stay of all proceedings against the defendants imposed by the May 1 scheduling order on February 27 status quo order. Okay. She goes on to say that she released the APE claims because the court rejected the cause as legally impermissible. Removing a clause that has no legal effect does not adversely affect the pursuant. I've ordered this case to date, July 22 letter, and all of its enclosures and this letter should be posted on the websites for AMC Entertainment Inc. no later than 8 p.m. today, June 24. Okay. Second, the opinion is not final determination of whether the settlement should be approved. The opinion pointed out the release was unsound and could not be approved, and encouraged the defendants to weigh the risk from a narrower release. In so many words, the opinion gave the parties an opportunity to narrow the release following a nuance of class action practice before this court, and as contemplated by the plaintiff's counsel at oral agreement. If the parties did not choose that path, the opinion directed to the parties to submit a consolidated plastic modification. So basically what she's saying there is, like, I get the feeling what she's saying there is she basically told them, I cannot approve this as is. You have no chance. You have to resubmit it, and if you even want a chance for me to approve it. That's what that sounds like to me. And now they've made the revision. Let's see here. She went on to say they should have finished this weeks ago. Remember, I touched on that the last time. The request did not lift the stay. This is very important, okay? Page 5 of 6. Because some people are going around spreading FUD, fear, uncertainty, and doubt, and they're saying, oh, the stay's lifted. The reverse split's going to happen. No, it's not. She says right here very strongly, This request did not lift the stay imposed by the May 1 scheduling order. The stay remains in place. I want to touch on that again. Okay. The letters request to stay my request for consolidated complaint and case schedules granted. Fourth, as for the status quo order, opinion stated, the status quo order remains in place. So nothing gonna happen. Everything's on lockdown, okay? She says, I asked the parties to submit the following notice of business needs on the horizon. Defendants represented that they need a decision before the capital markets go quiet in August. The court has made all effort to meet that business need. I raised my concerns about the release with counsel at the settlement hearing in June. Instead of addressing those concerns, the parties let the month of July pass and only sought to amend the release after I concluded the release was unsound. Please advise, with as much detail as possible, as to any events or circumstances compelling a decision by a certain date. She's basically saying to them right there in letter A, guys, she's basically saying to them, why are you rushing me? Why are you trying to force me to give notice in a ruling so quickly? Give me details, please, as much as possible as to why you're rushing me and compelling me to make a decision by a certain date. Powerful words by Judge Zurn. And then number 19 right here, it says, and so I guess the question I'm asking is, can we truncate it a little bit? And obviously we need to work backwards from a hearing date. But from the perspective of capital raising, once we get into the latter summer, that is typically a quiet period. So I'm a little worried about this dragging, fairly worried about this dragging into the fall. I do agree with Mr. Newest. There was a desire on the company's part for reasons that frankly we are sympathetic to, and to be able to do fundraising before the markets basically shut down. Okay, that looks like that was, okay, she's quoting them rushing her right here. That's an example. She gave an example of how they're rushing her. That's what she quoted right there. That's not her speaking, that's the plaintiff speaking there, okay? I'm not a lawyer, this is not financial advice, I'm not giving financial advice, this is my own personal opinions. Okay, here we go. Letter briefs, joint or separate on the effect date of Delaware Supreme Court June 28 decision. Costa versus UIP Companies, Inc. Proposed settlement, breach, fiduciary duty claim. Any response to the motion, particularly its preemptive request for a stay on lifting the status quo order if the settlement is approved pending appeal, or letter stating that no response will be forthcoming. Another revised proposed order and final judgment omitting Mr. Munoz as plaintiff and with a version in Microsoft Word. Because the narrow release does not adversely affect the putative class, the court will not consider any new supplemented objections other than the advocacy requested above. The record on the proposed settlement is closed. Sincerely, Morgan T. Zurn, Vice Chancellor. Okay, guys, you have it there, right from Judge Morgan T. Zurn, okay? I'm going to close this, and I'm going to go back to my commentary full screen. Hang on one second. Okay, friends, so I hope that gave clarification to you as to what's really going on with the newest Judge Zurn release. So we're going to watch things really closely every day and see what happens. I really want Ms. Izzo to be the lead plaintiff, but it doesn't seem like the judge really addressed that in the letter. Comment below. I'm curious to know what you think. I was thinking of starting a new petition to get Ms. Izzo added as lead plaintiff, but is it futile at this point, or do we have a chance? I want to know what's your thoughts on that part of it, because it seemed like she didn't even really address that. I'd love to know your thoughts on that. And what do you think about the whole judge's letter? Is it good for us or bad for us? What do you think? I think it's good for us. I mean, she seemed like annoyed by the plaintiffs and both legal parties. I don't know. So we're going to have to wait and see what happens. I'm just curious of your thoughts as well. So hit like, subscribe, and notifications. Share the video with a friend. I'll have more videos for you later today. As soon as we get some news, I'm watching everything very closely. All right, friends? Make sure you're subscribed. Talk to you soon.